Okay, so now we have unconscionability. So this is hybrid doctrine. It's process of assent and substance of agreement. And we're going to look at Williams v. Walker as the case, Walker Thomas Furniture Company. And that is the rent-to-own furniture store, where the terms were they found unconscionable because it was so one-sided. So this was the one where if you bought something and then you bought something else and then you bought something else, if you defaulted at all, even like after you bought these three things and you had like paid 99% of this one, if you defaulted, they took everything. So they said that was unconscionable. So unconscionability has generally been recognized to include an absence of meaningful choice on the part of one of the parties, together with contract terms which are unreasonably favorable to the other party. And in many cases, the meaningfulness of the choice is negated by a gross inequality of bargaining power. And you want to ask, did each party to the contract, considering his obvious education or lack of it, have a reasonable opportunity to understand the terms of the contract, or were the important terms hidden in a maze of fine print and minimized by deceptive sales practices? So ordinarily, one who signs an agreement without full knowledge of its terms might be held to assume the risk that he has entered a one-sided bargain. But when a party of little bargaining power and hence little real choice signs a commercially reasonable contract with little or no knowledge of the terms, it is hardly likely that his consent or even an objective manifestation of his consent were ever given to all the terms. In such a case, the usual rule that the terms of the agreement are not to be questioned should be abandoned, and the court should consider whether the terms of the contract are so unfair that enforcement should be withheld. So we have that's the argument of unconscionability, and there's some public policy things in another video. Why is the court interested in unfair terms? Inquiry into the relative bargaining power of the two parties is not an inquiry wholly divorced from the general question of unconscionability, since a one-sided bargain is itself evidence of the inequality of the bargaining parties. This fact is vaguely recognized in common law doctrine of intrinsic fraud, that is, fraud which can be presumed from the grossly unfair nature of the terms of the contract. So, in Williams v. Walker Furniture, why was the contract held to be unconscionable? Well, there was an add-on clause. It had very take it or leave it terms, and there was a lack of understanding. This thing keeps coming up on my screen. So the types of unconscionability, and there is procedural unconscionability, so superior bargaining position, quasi-coerced terms, and hidden and complex terms. And then we have substantive unconscionability, and that's grossly one-sided. So this is our kind of branch between the substantive, or from the procedural issues, the mistake, the duress, the undue influence, all the problems with how like procedurally we created this contract, to our substance ones that we're going to go into next. But this is, so this one kind of hits both. So it is grossly one-sided. Okay. The Uniform Commercial Code says 2302 unconscionable contract or clause. If the court, as a matter of law, finds the contract or any clause of the contract to have been unconscionable at the time it was made, the court may refuse to enforce the contract, or it may enforce the remainder of the contract without the unconscionable clause. And it may so limit the application of any unconscionable clause as to avoid any unconscionable result. Okay? When it is claimed or appears to the court that the contract or any clause thereof may be unconscionable, the parties shall be afforded a reasonable opportunity to present evidence as to its commercial setting, purpose, and effect to aid the court in making the determination. Comment 1. This section is intended to allow the court to pass directly on the unconscionability of the contract or particular clause therein and to make a conclusion of law as to its unconscionability. The basic test is whether, in light of the general commercial background and the commercial needs of the particular trade or case, the clauses involved are so one-sided as to be unconscionable under the circumstances existing at the time of making the contract. The principle is one of the prevention of oppression and unfair surprise, and not of disturbance of allocation of risk because of superior bargaining power. So oppression and surprise is what we're looking for. Okay, restatement, unconscionable contract or term. If the contract or term thereof is unconscionable at the time the contract is made, a court may refuse to enforce the contract. It may enforce the remainder of the contract without the unconscionable term, or may so limit the application of any unconscionable term as to avoid any unconscionable result. Comment D, weakness in bargaining process. A bargain is not unconscionable merely because the inequality results in an allocation of risks to the weaker party, but gross inequality of bargaining power, together with terms unreasonably favorable to the stronger party, may confirm indications that the transaction involved elements of deception or compulsion, or may show that the weaker party had no meaningful choice, no real alternative, or did not in fact assent or appear to assent to the unfair terms. So Restatement 208 says, but gross inequality of bargaining power, together with terms unreasonably favorable to the stronger party, may confirm indications that the transaction involved elements of deception and compulsion. And then here's a recap for the exam. Williams v. Walker. Unconscionability includes both procedural and substantive element. Absence of meaningful choice plus terms which are unreasonably favorable to the other. So absence of choice, terms that are unreasonable. Court considers the following factors: gross inequality of bargaining power, important terms hidden in a maze of fine print and minimized by deceptive sales practices, and where there is procedural unconscionability, court then should consider whether the terms of the contract are so unfair that enforcement should be withheld. UCC 2302, comment 1, appears to want courts to consider both procedural and substantive unconscionability. Prevention of oppression and unfair surprise. Clauses involved are so one-sided. UCC rejects superior bargaining power as a factor. Instructs courts to look at superior bargaining position in addition to other factors, says Restatement 208. So UCC doesn't like superior bargaining power look at through that lens, but the restatement does. And then Higgins v. Superior Court of Los Angeles, this was about arbitrate and arbitration clause. So there is a separability doctrine here. Separability. People get wrong. Separability. Under the separability doctrine, as adapted by the Supreme Court in Prima Paint, an arbitration clause is separable from the main contract entered into by the parties. In other words, the agreement to arbitrate is treated as a separate contract from the underlying contract, so that the arbitration agreement is untainted by any claims of unconscionability against the underlying contract. So the scope of the unconscionability doctrine: allegations of unconscionability directed at the contract as a whole are to be decided by the arbitrator. However, allegations of unconscionability directed at the making of the agreement to arbitrate itself need not be submitted to arbitrators, but instead should be considered by the court. Types of factors, so we've seen that a lot in the courts now. There's been some law firms. I think Uber was up for that. Netflix, maybe. There's been a lot. Maybe not Netflix. But there's been a lot of challenges to arbitration agreements. Types of factors that give rise to finding unconscionability. We have adhesive nature of contract, so that's superior bargaining power, but contracts of adhesion are like take it or leave it. Procedural unconscionability, there's hidden terms, there's lots of fine print. In this case, the arbitration agreement was like buried in other terms, even though there was like big headings on some. This was not one of them. And substantive unconscionability, one-sidedness of arbitration provision. So if I've got to arbitrate, you need to arbitrate. It shouldn't say, well, like, you need to arbitrate and I don't need to. That's not the thing they're going to uphold. Okay, we're going to put unconscionability of public policy in this one too. So it's going to be a little longer, but it'll all be together. So where does public policy come from? Restatement 178, when a term is unenforceable on grounds of public policy. A promise or other term of an agreement is unenforceable on grounds of public policy if the legislature provides that it is unenforceable or the interest in its enforcement is clearly outweighed in the circumstances by a public policy against the enforcement of such term. Okay, basis of public policies against enforcement 179. A public policy against the enforcement of promises or other terms may be derived by the court from legislation relevant to such a policy or the need to protect some aspect of the public welfare, as is the case for judicial policies against, for example, restraint on trade, impairment of family relations, and interference with other protected interests. And then public policy substance of process. So process defenses are duress, fraud, and undue influence. Hybrid defenses are unconscionability. And substance defenses, this is the public policy. So we're going to look at which public policies. Public policies designed to protect the public will void a contract. Public policies designed to raise revenue will generally not void a contract. And any restraint on trade. So that's like non-compete clauses. Restatement 186, promise and restraint of trade. A promise is unenforceable on grounds of public policy if it is unreasonably in restraint of trade. A promise is in restraint of trade if its performance would limit competition in any business or restrict the promiser in exercise of gainful occupation. Covenants in restraint of trade. Some legitimate interests. Protect an employee from luring away a former employer's customer base while the employer is vulnerable. Protect effective transfer of goodwill, which has already been factored into the price of the business. So, considerations in evaluating reasonableness. What job industries does the covenant include? What is the geographic scope of the covenant? What is the time span of the restricted covenant? So 5 years, the whole country, that's not going to hold up. But like a year in the county in which like everyone is, the places probably. You can't like buy a pizza shop, run it for a year, and then leave and go build your own next door. It's probably not going to work. Some courts use the blue pencil rule, somewhat mechanical cross-out rule. So they'll just cross out. The courts will cross out what they don't like. But other courts know severance at all, not willing to engage in rewriting an agreement. Restatement 184, more flexible approach. A court may nevertheless enforce the rest of the agreement if the performance as to which the agreement is unenforceable is not an essential part of the agreed exchange. However, a court will not aid a party who has taken advantage of his dominant bargaining power to extract from the other party a promise that is clearly so broad as to offend public policy by redrafting the agreement so as to make the part of the promise enforceable. The fact that the term is contained in the standard form supplied by the dominant party argues against aiding him in this request. Methodology in the absence of legislative direction. Court notes that there are very few appellate decisions addressing... Oh, okay, so this was the selling of the baby. So, I'm just going to talk through them because unless this will be a very specific question, but courts note that there Court adopts baby M methodology. Try to discern public policy from other legislative provisions. Different statutory approaches to surrogacy. Some states deny enforcement of all such agreements. Some states deny enforcement of such agreements only if the surrogate is to be compensated. Some states simply exempt surrogacy agreements from provisions making it a crime to sell babies. You shouldn't sell babies. Some states have made surrogacy agreements lawful. Some states require the intended mother to be infertile for the surrogacy agreement to be enforceable. Arkansas raises a presumption that a child born to a surrogate mother is the child of the intended parents and not the surrogate. Courts look at existing legislation for an analogy. Surrogacy fatherhood, accepted procedure. Biological father has no parental rights. That's a sperm donor. That's not necessarily the surrogacy. That's a weird term, but they're talking about a sperm donor. Does surrogacy fatherhood serve as a useful blueprint to the court? Court decides no. Surrogacy motherhood is never anonymous, and her commitment to the contribution is unavoidably much greater than a sperm donor, which is true. Court looks to existing legislation for an analogy. Adoption requires the written consent of the father and mother, and such written consent is not to be executed sooner than the 4th calendar day after the birth of the child to be adopted. Does this rule serve as a useful blueprint for the court? Court said yes. Mother should have time after the child's birth to reflect on her wishes. Court looks to existing legislation for an analogy. Adoption. Adopting parents may pay for expenses of birth parent, but may not make direct payments. Does this rule serve as a useful blueprint for the court? Court decides yes. Although in the present case there was no formal adoption, circumstances amounted to surrogate mother giving up parental rights because failing to grant father custody would require repayment of fees. Court says yes, despite important difference that surrogate mother enters agreement prior to conception of the child. Court's option for surrogacy: no compensation beyond pregnancy-related expenses, no consent of the father's custody until after the child is born and a suitable waiting period has passed. Mother's husband must give informed consent in advance. Mother must be an adult and have at least one successful pregnancy. Mother and husband have been evaluated for soundness of mind. Father's wife is incapable of having a child without risking her health. Intended parents are suitable. All parties have advice of counsel. 191. Promises affecting custody. A promise affecting the right of custody of a minor child is unenforceable on grounds of public policy unless the disposition as to custody is consistent with the best interest of the child. In pari delicto, translated is equally culpable. General rule is that where both parties are equally culpable, the court will typically leave the parties where it finds them and will give no remedy to either party, even if one has received a benefit from the other. Restatement 197, restitution generally unavailable, except as stated in 198 and 199. A party has no claim in restitution for performance that he has rendered under or in return for a promise that is unenforceable on grounds of public policy, unless denial of restitution would cause disproportionate forfeiture. Part of that surrogacy case was they used the surrogate's egg, which makes it super messy. I think actually in California that cannot happen. They won't allow it. That's unconscionability.